And I have, looks like Austin Weeks. And the other individual in custody, I cannot quite make out. It's kind of small.
Sorry, it's Jeremiah Judge.
All right, thank you.
No.
Oh, Jeremiah Wagner. Yes, long time no see. Jeremiah Wagner. It's got to be on it. One, I believe. Oh, no. He's not on until 2.
Oh. Okay.
I could do him. I could just have, he can sit. Mr. Polisky and Mr. Vila, is that your case, Mr. Jeremiah Wagner? Is that
that's a DA Schmidt case, but we could do the status now.
All right, we can just do the status now. Since he's here, we'll just take care of that. But I'm going to do Ms. Olson's case first. And you were with Mr. DeCassi, if I'm remembering correctly.
Yeah.
Yes. All right.
What you're about to witness is not just a routine courtroom calendar. It's a rapid-fire look at how the justice system handles repeat appearances, missed court dates, bond decisions, and accountability in real time. From defendants appearing by video to judges juggling packed dockets, every decision here carries consequences. Pay close attention because what starts as paperwork quickly turns into serious legal pressure, and not everyone handles it the same way. The question is, who's taking this court seriously and who isn't?
Feeling busy?
We will go on the record in the matter 25 CF 136, State of Wisconsin versus Zachary DeCassi. The state appears through Assistant District Attorney Jose Vila in person. We have Angela Olson, defense counsel by video. We also have Mr. DeCassi by video. We're set today in this matter for an initial appearance. We've been here before. There was an issue with the preliminary hearing. The matter was dismissed. It was not refiled. Ms. Olson, able to again, or does your client still recall the charges that were charged at the maximum possible penalties?
Yes.
Waive formal reading?
Yes.
Not guilty as to the disorderly conduct?
Yes.
All right. And are you still on Wood Street, Mr. DeCassi?
Yes, ma'am. For your honor.
All right. Thank you. And I have a different telephone number in my file versus the one you called with. Is there one that you would prefer if we send text message notifications to?
651-354.
That's the one we have. So yeah, that's good. All right. So thank you for that. All right, let's get a preliminary hearing scheduled. Ms. Olson, are you requesting it within time limits?
No, we waive time limits, Your Honor.
And again, Ms. Olson, this is up to Mr. DeCassi and yourself. You may appear by video conferencing for that preliminary hearing. The only thing is that he would need to stipulate as to his identity.
Understood. Thank you.
And this is yours, Mr. Vila?
That is correct, Your Honor.
I hear a telephone that went beep. Maybe it's on a video. Oy, oy, oy. It's looking like I'm going to the new year. I can put it under, well, no, I'm going to keep this one under me. Wowza. Can we do it as early as next week?
What day, Your Honor?
We could do Monday, the 27th, if we could do that, that soon. Either 9 or 9:30. We can do October 28th, that Tuesday, 9, 9:30, 10, 10:30, or 2:30 or beyond. That's about what it's looking like.
Unfortunately, those times do not work. I have all day on the 29th, but otherwise next week is tough.
All right, I'm going to have to do it on a Schmidt week, but no, to put it back on your week after the prelim. I could do either November 17, your pick, your call, or November 18, anytime in the morning.
I could do, actually the 17th I'm in all day hearing, and the 18th I'm all morning I'm booked.
I could do 10:30 on December 8 or 3:15.
I can do, said 10:30.
Yes.
I can do that.
All right, 10:30 on December 8. Anything else to address here today? Well, I think we had a bond on the last time, victims' rights compliance.
Yes, Your Honor.
Are they asking for any type of specific request on bond?
Leave that to the assistant.
Your Honor, I have not heard anything updated from the last time we had the conversation with the victims regarding bond.
And what was it on the last time, if you can refresh?
No abusive contact was requested and the required classes were completed by both parties.
Okay, all right, so I'll do bond. He's showing that he's appearing. He has, he's retained an attorney. He's local. I'll do $1,000 signature bond, no abusive contact with victims and or the residents. So, Mr. DeCassi, that's going to need to be sent to you. Or you can drive here to the courthouse to sign that. But if it is mailed to you, please sign that and get it back to the court as soon as practically possible. It is better if you're able to work it into your schedule to come sign it.
Yeah, that's fine, Your Honor. I guess one thing I'm curious about the $1,000 bond, is that I'm gonna have to bring in $1,000 as well
Nope.
as sign the bond? No? Okay.
It's just a signature. It's just telling me that you understand that if you violate the bond conditions, then it would be converted to $1,000 cash.
This is an important moment to pause on because many people misunderstand what a signature bond actually means. No money is paid up front, but the court is making it crystal clear that violating conditions instantly converts that promise into real cash liability. Add in absolute sobriety requirements, no alcohol-related locations, and no abusive contact, and suddenly the stakes are much higher. So here's the real question for viewers. If you were in this position, would you take these conditions seriously or risk turning a warning into a financial disaster?
Okay.
I'm also going to say, I don't recall what was on the last bond, but absolute sobriety, no alcohol, no bars, taverns, liquor stores, or any establishment with the primary purpose for the sale or the service of alcohol, okay?
Yeah.
All right, anything further?
Not for me, Your Honor.
No,
Ms.
Judge.
Olson? All right, thank you. We are adjourned. We're going to do the 2 o'clock, Mr. Wagner. I don't know if that sets you off or anything. We will go on the record in the matter 24 CF 119, State of Wisconsin versus Jeremiah Wagner. The state appears through Assistant District Attorney Jose Villa in person. We have Mr. Joel Feliski defense in person. Mr. Wagner appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a status conference. Mr. Wagner was on a warrant absconding for a significant period of time. For whatever reason, he is now in custody. I'm not sure. I know he has corresponding St. Croix County matters. I'm not sure what's happening in those cases in St. Croix County. His co-defendant has already pled out and has already handled her cases. Other than that, do you have any other update, Mr. Feliski?
Thank you, Your Honor. I will let the court know that I was fairly recently appointed to this case, so I still need an opportunity to review the file in full and to speak with Mr. Wagner regarding what he would like to do. It is my understanding as well, Your Honor, that the co-defendant in St. Croix was sentenced. I don't believe there's been a resolution, though I do understand from a review of CCAP, both for this file and the St. Croix matter, that the matter was trending, at least as of the last time this case was on the docket, towards resolution. So I'm just asking for a status conference to get caught up with everything, discuss with Mr. Wagner, and see how this is actually proceeding.
I'm not even quite sure. Have we had, yes, we had the prelim. Okay. All right. So let's get the matter. Well, here's what I'm going to do. Full disclosure, I'm pulling up a St. Croix County matter right now. I want to see when he is next scheduled for court there and what is taking place. Because these are very closely connected.
Your Honor. So I was taken into custody, and then we were pulled over, and I just gave the officers my name. And then, so they took me into custody for the warrants. And then I paid my $500 bail in St. Croix County, and then was transferred over here.
Yes, and I'm seeing that right now. He had a $500. He absconded on September 29th, 2025. Oh no, that was a return on warrant. There was a bench warrant issued February 24th, 2025 for his failure to appear, or he appeared by Zoom. He was not provided that, or there was a child support warrant or something of that nature out. Warrant was issued, return on warrant September 29th, 2025. He then posted his $500 cash bond from that warrant. It looks like he has a preliminary hearing scheduled October 24th at 11. I'm not quite certain if he's going to be permitted to do it by Zoom. He is currently under this court's failure to appear, and it's set right now. It was a $50,000 warrant, cash warrant. So I guess I need to discuss the bail and reissuing bail in this case. From March, so March, it's about, he was absconding about 7 months. A lot of cash was forfeited in this case, 10 grand for his failure to appear.
This is where the courtroom tone shifts, and it's not subtle. The judge isn't guessing anymore. She's reading the record. 7 months of absconding, prior forfeited cash, and repeated failures to appear all tell the same story. Previous bond amounts weren't working. When a judge doubles bail, it's not punishment, it's prevention. Courts don't raise bonds lightly, and this moment sends a clear message. Ignore court orders long enough, and the system will tighten its grip. Do you think $20,000 is justified here, or is this the result of choices stacking up?
The court is going to set at least this at $10,000 was not enough to assure his appearance. The court is going to set it at $20,000, same conditions. We need another court date. December 8th at 1:15, December 8th at 1:15. That is your status block date, Mr. Feliski, unless you would like the court to look for something else.
That will work for my calendar, Your Honor.
All right, then we will see you then. Thank you. Do we have prelims? Am I needed? Do we? Okay.
Your Honor, I have Jennifer Rawls.
Ms. Rawls? We will go on the record in the matter 25 CF 138, State of Wisconsin versus Jennifer Rawls. The state appears through Assistant District Attorney Jose Villa in person. We have Joel Feliski, defense in person with Ms. Rawls. we're set here today in this matter for an initial appearance. Mr. Feliski, you're making, according to my calendar, you were making a special appearance, but you have now been retained and appointed to this case. Were you able to go over the criminal complaint with Ms. Rawls?
I was, Your Honor. I believe she understands the charges here and the maximum penalties. We'll waive formal reading. To the misdemeanor count, we'll enter in a plea of not guilty, and we'll waive time limits for setting a prelim.
That guilty plea will be entered on your behalf as to that matter. As to a prelim, of a lot of time next week. Preliminary hearing, we could do Monday, November 3rd at 2 or the 4th at 11:15.
That time on the 3rd will work for my calendar, Your Honor.
November 3rd at 2, preliminary hearing. Mr. Vila, is this your matter or Mr. Schmidt's?
This is a DA Schmidt case, Your Honor.
Excellent, so I put it on the right week. All right, so then preliminary hearing, then we do need to address bond. Unfortunately, fortunately for you, you were lucky, Ms. Rawls. The court set a cash bond in this matter with those allegations. However, it was a book and release, so now we just need to ensure that there is the conditions of the court. What is the state requesting?
Give me one moment, Your Honor, just reviewing the case. Given the allegations, Your Honor, the state would be requesting a low cash bond in this matter.
What does that mean?
Was the bond not need to be set for this matter?
It does need to, but what do you mean by low cash?
A $250 cash bond, Your Honor.
Mr. Feliski?
No objection to that, Your Honor.
All right. I need to pull up something else. We do need to set a sheet in her other matter, 24 CF 169. Are you going to represent her on that matter too?
I am not sure, Your Honor, whether that would be me or Attorney Reed, her former attorney. I'll have to ask my office.
All right, because a motion for revoking the DJOC has been filed. I guess we can wait to set that after the preliminary hearing to see what happens there. All right, for a bond, at least at this time, $250 cash as requested by the state. No contact with victim while Bill's gas station. You may not work at any of the following unless there are eyes on at all time, eyes on person at all time supervision. Any establishment that sells merchandise for retail sale, any position that handles money, any employment as a house or office cleaner, unless you have 24 eyes on supervision. It's going to take a moment for the clerk to be able to prepare your bail bond. When it's done, you can come up here and you can sign it, but you do need to go and pay that cash before you leave. All right? Anything further?
Nothing further at this time, Your Honor.
Mr. Feliski, do you have other people? I see, I see Enyer Gonzalez Espinales,
Mr. Gonzalez?
but we can wait. We don't have to give, but do you have anyone else other than that?
I believe that would be the only one I have, Your Honor. Oh, Marcus Maxwell, Your Honor. I apologize. Mr. Maxwell?
Sure. A little higher up. Let's do the defendant. No, 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 Jennifer, no, where it says defendant signature.
Yeah. Yep.
All right, and I will make a copy of that.
Does she have a warrant?
Okay, don't worry about that then. We're good.
We can wait. We've time.
It just won't copy, so.
So we'll just. We will go on the record in the matter 24 CT18, State of Wisconsin versus Enyer, Johan Gonzalez Espanol. It's Espanales. Am I saying it close?
This is Marcus Maxwell, Your
Oh, that's
Honor.
Marcus Maxwell.
I apologize. We
I'm
had brought
sorry.
that up and
We brought it
Yep.
up and then you switched somebody else.
Yep.
Okay. Marcus Maxwell. Why does that ring?
5 CM 206.
Thank you. Okay. We will go on the record in the matter 25 CM 206, State of Wisconsin versus Marcus Maxwell. The state appears through Assistant District Attorney Jose Villa in person. We have Mr. Maxwell in person with counsel Joel Feliski. Mr. Feliski, this is an initial appearance. Have you been able to go over the criminal complaint with him?
Your Honor, I believe Mr. Maxwell has received a copy of the complaint. It seems that he understands the charge here and the max penalties. We'll waive formal reading and enter in a plea of not guilty.
All right, not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. I see you have other open matters, and Mr. Feliski, you are on those as well, correct?
Yes, Your Honor. I believe I was just appointed to all of Mr. Maxwell's current cases.
All right, and so I'm going to schedule you for the same date and time. October 29th at 1:30. Well, unless you want a little bit more time, Mr. Feliski, since you're just getting on all of the cases, is that what you're saying?
Your Honor, I would be open to that. I was recently appointed, so it would be good to get caught up with everything.
So give you another day?
Yes, please, Your Honor.
All right, then I need to know which other cases he has. 25 CM 103, 25 CM 106, 25 CM 167, 25 CM 206. All right, so we can reschedule all of those. I just need to make sure I take notes. All right, so schedule another date and time just to give you a little bit of time. Mr. Villa, is this your matter?
That is correct, Your Honor.
Well, I guess it's your December. I have you coming December 8th at 1:15.
That'll work, Your Honor.
All right, so December 8th at 1:15. You can move along. Okay, thank you. All right, so we will see you then December 8th at 1:15. I'm going to hope that there's a little bit more discussion on the other matters now that you're getting
Absolutely, Your
in a
Honor.
row. All right, you can come get your notice and you're free to leave. Mr. Gonzalez Espanales. We will go on the record in the matter 24 CT18, State of Wisconsin versus Enyer Johan Gonzalez Espanales. The state appears through Assistant District Attorney Jose Villa in person. We have Joel Feliski, defense in person. We do not have Mr. Gonzalez Espinales. The matter was set for 1 o'clock today. It is 1:26 and no appearance. There are no hazardy road conditions. He should be able to get here, or at least request to appear by video conferencing, because I have a DeForest, Wisconsin address. I'm not sure if that's correct or if it's not correct. He fails to appear. What is the state requesting?
The state would request a warrant, Your Honor.
Mr. Feliski, would you like to provide argument or stand mute?
Stand mute, Your Honor.
The court is going to issue a warrant. The court currently had cash in this matter in the amount of $750. That was not enough to assure his appearance. The court will issue a warrant, $1,000 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. The cash previously posted will be forfeited pursuant to 969.13 of the Wisconsin statutes. We are adjourned. Thank you. No one else, Mr. Feliski?
Your Honor, I believe that's Brian Alden on the Burnett County Zoom. Also another case where I was very recently appointed, but I think I should be able to go through the initial.
We will go on the record in the matter 25 CM 182, 25 CM 215, State of Wisconsin versus Brian Alden. The state appears through Assistant District Attorney Jose Villa in person. We have Joel Feliski, defense in person. Mr. Alden appears by video conferencing in custody in Burnett County Jail. We're set today in these matters for initial appearances. Mr. Feliski, were you able to make contact with Mr. Alden and go over the criminal complaints?
Your Honor, unfortunately, due to the recent appointment, I was not able to speak with Mr. Alden prior to this hearing. I do want to clarify to the court, it's my understanding that he wants representation only on the 25 CM 215 matter. The other matter, to my understanding, with the information provided to me, he wishes to represent himself on at this time. That may change, but that is the most recent information that I have. With the court's permission, I would be happy to go into a breakout room and review the complaints so that we can proceed.
All right, I would appreciate that. Thank you. We are briefly adjourned on that matter. I'm going to go to Mr. Weeks.
Excuse me.
We will go on the record in the matter 25 CM 188, State of Wisconsin versus Austin Weeks. The state appears through Assistant District Attorney Jose Villa in person. We have Mr. Weeks appearing by video conferencing in custody in Burnett County Jail. We're set for an initial appearance, but all I'm seeing is a possession of drug paraphernalia matter, and I don't believe that there is any cash bond being requested. So, Mr. Weeks, are you on a hold?
No, Your Honor.
Oh, you're on failure to pay child support warrant. Okay, that I cannot address right now. But with regards to this matter, you're here for an initial appearance for an allegation of possession of drug paraphernalia. Mr. Villa, is there an offer that can be presented?
Yes, Your Honor. The offer would be to amend the charge to an ordinance citation for cost.
Mr. Weeks, would you like to accept that offer and not have a criminal charge assessed against you? Would you like it to be amended to an ordinance and to plead to that?
Yes, Your Honor.
Formal motion to amend?
So moved.
Granted. How do you wish to plead? Guilty or no contest?
No contest.
The court will enter no contest plea on your behalf here today. I will assess $150 cash to be paid, I'll say within 60 days, or to make sure that you set up that payment plan with the clerks, okay?
Okay.
We are adjourned.
Today's docket highlights the full spectrum of courtroom accountability, from defendants given second chances through signature bonds to others facing escalating consequences after ignoring court authority. We saw how bond conditions, failure to appear, and cooperation directly influence judicial decisions. The takeaway is simple but powerful. Courts remember patterns, not excuses. If you found this case breakdown insightful or surprising, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom moments explained clearly, professionally, and without the fluff.